Hi, my name is Mark Monlux, and you're at a question and answer session of Ask Mark. I'm a freelance illustrator inside Tacoma, Washington, and I kind of pride myself on being up on contracts and legal issues. Sometimes I have my friend Daniel Abraham with me, and he's a lawyer on the East Coast, but he's not with us today. I'm going to have the people who are attending today's Q&A go ahead and introduce themselves.
Okay, I'll start. Can you hear me?
Yes.
Yep. Okay. Hi, I'm Rosanna Von Sacken. I'm based in Metro Vancouver in Canada. I am a certified professional facilitator, and I also do visuals to supplement my work that complement my facilitation and coaching work, as well as video creations.
Great. Hi, I'm Shirley Mayer, and I am in Chicago, Illinois, and I am a organizational effectiveness consultant and human resources maven, and I do graphic facilitation to complement my organizational development, training, and individual coaching. And I'm really delighted to get this information today. Thank you.
So haven't really put in any type of a topic other than this would be a discussion about contracts and licensing and copyright. So I'll just start fielding your guys' questions and do the best I can.
Well, what were the questions that initiated? I'm looking on the graphic facilitation page that prompted this to begin with.
Well, what prompted this was people were looking for contract templates and wanted to know, what are the basic contracts out there, what should be in a contract. They also were kind of curious about licensing. So here is why contracts are extremely important for creative professionals, especially people like us who draw. According to U.S. law, a copyright is formed when an idea becomes tangible. The idea itself, to protect the idea, you get a patent. But when you show a representation of an idea, that falls underneath copyright, and it becomes active and live the moment you draw a line, you sing a note, or basic, or onto a recorder, or any way that you take that expression of an idea and manifest it. This can be through choreography, writing songs, writing books, poetry, 3D sculpture, which includes crafts and earrings, musical composition. So there's a broad range of anything that can show how you encapsulate or record an idea. Then it becomes copyright. It becomes a copyright. Now, here's the really, really important thing. The only way someone else can use what your copyright is if you license it to them, or you basically give permission, but the permission needs to be in writing. And this is why a contract is very important. You may want to give or license full rights to your work in such cases as a company logo, but you don't necessarily have to. There are situations when you want to retain rights of a particular work and then license it out piecemeal. Most of the work that graphic recorders do is done with an understanding that it's going to be the client's work. However, you need to have a contract that says you are providing them full rights to do with what they want with that image. Otherwise, no transfer occurs and your client is left in a lurch. That is why it's very important to have some sort of contract.
Mark, how does...
Go ahead.
Sorry, Shirley. I was going to ask, what's the difference between the license for use versus the Common Creative licensing?
Creative Commons, when a person creates a piece of artwork, and put it up on Creative Commons, that is a written record that they are making it available to anyone for free use. So in a way, they have signed away the rights by placing a Creative Commons stamp on it. But again, there was some sort of permission granted in writing to have that done. There are situations, if you were, say, the term work for hire, a lot of people will say, oh, but you're doing this work for hire for my company. If something is done work for hire, that means the company's in charge of fulfilling or filing or registering the copyright. Well, I'm going to get into why it's important to register a copyright in just a moment. But the thing is, even if your contract has the phrase work for hire written inside of it, there are several legal aspects as to why you are not work for hire. Typically, a person who's doing stuff work for hire is an employee of the company. Now, unless we're all contractors by nature and we're being hired piecemeal, you're not working for company A every single day. Otherwise, your work wouldn't belong to them. There was some court cases that happened with Microsoft that set some really strong arguments to why contractors need to be seen and viewed as contractors, and that even if it says work for hire in the contract, or if it says work for hire on the back of the check, there's an argument can be made that that is not work for hire. So if you're an independent contractor and you're working for somebody else on a contract basis, the best thing you can do is get the licensing taken care of straight away by saying, okay, it's going to be a full rights. What full rights means is that they have access to it over all 6 or 7 of the licensing criteria. The licensing criteria could be the type of media it's being shown in, the form or medium it's going to be used in, the size within that medium, the lifespan of that medium, how long it's going to be up, the geographic location of that medium, the quantity of that medium, and also the importance of the image. For example, if I did an illustration of a crab on the inside of a brochure, and the brochure had a quantity run of 50,000, so now we know 8.5 by 11 brochure, it's located on the size, that's determining the size. It's also it's got less exposure because it's on the inside of the brochure. The quantity run is 5,000. The time period is going to be a year. Any type of license past that, a reuse fee would be negotiated. That's why when people or illustrators do an image, they can license it multiple times over a broad spectrum of uses and make money. I have a simple smiley face sun that I made back in the late 80s. The first time I licensed that was for the inside of a brochure, and I got $600 for it. But over the decades, I've licensed that same image multiple times, and I've made about $17,000 off that one image. It's my most popular image. I haven't licensed it for about the last 4 years, but I haven't promoted it that way. When we do stuff for graphic recording or graphic facilitation, one of the reasons we can charge such a significant day rate is because we are asking for a full rights buyout, meaning the client can do anything with that piece for as long as they want, for whenever they want. And that's why we don't do work by the hour. At least that's why I'm assuming we don't do work by the hour in this profession. I do have an hourly buyout rate that I have for some of my clients. Excuse me, I'm going to check. There were a couple beeps. I want to see if there were some messages coming in. Looks like somebody wants in. I'm going to go ahead and add them. I'm also going to post this live. I'm going to send out a Twitter.
Shirley, may I ask you to type up your questions in the chat box while Mark is doing his thing, please?
Sure. I'm somewhat new to Hangouts, so I need to find it. Yeah.
For those of you who are following on Twitter, the hashtag is Ask Mark Monlux. That's MERKMONLUX.
All right, so where's the maybe I found it. I found it.
Now I have to find the chat box.
It's in the top left, yeah, next to the Google thing. When you move to the left, it opens up. Yeah. I'm honored to teach you something, my friend.
There it is.
Can you see the questions I posted?
Yes, and I'm going to read them off. The first question is copyright not automatic even if you don't register it? Copyright is automatic. However, your protection for that copyright does not really go into effect until you register that copyright. For example, and this is why as soon as you create something, you should register it at the Copyright Office immediately. You can do that electronically, or you can do that hard copy, but it's much easier to do it electronically. I also like how the Copyright Office has it set up so that you can be part way through the process, save it, and then come back and fill out the rest of the copyright. What it does in the United States, and this might be different from other countries, is when you register your copyright, you can, if you go to court, get legal fees. That's the important thing. The next thing you can do is get paid for the value of the work, and then on top of that, receive awards depending on how mean or aggressive the infringement was, and this can vary I'm trying to remember if the cap on it's $120,000 per infringement, or if it's a little higher or a little lower. It varies from year to year sometimes because they make changes. But often, if someone is infringing on your work, and if they are doing it aggressively, then they're probably using that same piece in for every way they use it. That's another infringement. I mean, just if they're putting it on everything, everything's a lot. So you can have multiple, you can come at them for multiple infringements. If they're using it on, say, wrapping paper, greeting cards, paper plates, online, how they're using it online. Are they using it as a PDF? Are they using it in print? Each time they use it, that's an additional infringement. If you don't register for copyright, you don't get any of that. First of all, you'll have to fight. The first thing any lawyer is going to do is say, file your copyright or register your copyright, because they can't get legal fees. What's the incentive for them to go after that guy if they don't get their fees and the other guy's fees? Charging the other person for their time in court is a big bargaining incentive towards settlement. But that doesn't happen until you register your copyright. And I know registering's a pain in the butt, but consider it like this. It's a once-in-a-lifetime insurance policy that you buy for something that you've created. And then you don't have to worry about it. It's covered for your life and then some. 95 years, your heirs can use that copyright. Now, how copyright works from country to country varies, but there's something called the Berne Convention. It happened in the late 1800s, and it was basically a way for all the countries to agree on what type of copyright laws and what were the basics that would be protected. Oddly enough, the U.S. is one of the last people to abide by the Berne Convention. I think there's only a few countries, like Iran is not part of the Berne Convention, maybe a couple others. But take a look at your licensing for the copyright. If you're in the Canada, file your copyright in Canada. The U.S. will respect it. A question from Shirley. I was told to put a copyright on my work that I do for my business, but not for my clients, part of paid agreement. For example, I created some images for my website. I have not registered those. What are your thoughts? Well, we got a three-part thing happening here. A lot of clients don't like to see your copyright symbol on the projects that you do for them. I put it on there until the client takes it off, because I believe it's my responsibility to register that artwork. Here's what's going to happen. Your client is going to get lazy and they're not going to register the work. Suddenly they're going to come to you and say, Mark, we decided to use this particular element that you drew one day, and we decided to use that as a logo, and it's on all of our products now, but our competitor has decided to use the same logo. Well, that's going to cause a bit of a mess, because unless I had registered on behalf of my client, if it was me, they wouldn't have anything to worry about, because I register the copyright and it's taken care of. But if the client said it was work for hire and they would take care of it and they didn't register the copyright, then they're in a bit of a hurting situation. They have to contact a lawyer, but the first thing they have to do is they have to register, but then a case can be argued that they didn't have the copyright, or the other person had filed and registered their copyright first. It turns into a quagmire. So I just don't let the client deal with that. I always register the work. And I always have it in my contract that says full rights. But just because it says full rights doesn't mean that it's work for hire. If it was work for hire, it would be their responsibility. If it's full rights, it's my responsibility. I know that I'm going to file for that and put out the safety net. Otherwise, I can't rely on them. If you have your own images on your website, here is what I recommend that you do. And my friend Daniel, he agrees with me completely on this. Before you put the images on your website, have a blog. A blog is considered a periodical publication. You have roughly a 90-day window to register your copyright. So that means that anything that you put in your blog every 3 months, you can take that and register that as a periodical publication. That's one of the copyrights that you can register for. And then for that quarter of the year, everything you did is copyrighted and taken care of. And then any time you post your image thereafter would be a derivative from the original registration and would be protected. So I would highly recommend that you establish a blog, even if you only post stuff on it every 3 months, and that you post your images there before you start using them elsewhere on your website. WordPress is considered a blog. So if you're having your portfolio on WordPress, that's perfect. However, a static website is not considered a periodical publication. That's probably as clear as mud, but I'm just throwing it out there.
It's 5 o'clock.
Let's see. Roseanne asked, by putting a copyright on your materials, does that assume you have the copyright ownership even without registering? Yes. But a copyright insignia on your work, a copyright notice on your work without registration has about the legal equivalent of a keep off the grass sign. Everyone assumes that it's protected, but they don't know. I mean, that's the nice thing about it. When someone sees that copyright notice, they're thinking, oh, they registered. But so many people think that just having the copyright symbol there means that it's fully protected, and it's not. And some businesses know this and will go ahead and use it anyway. So surprise them and register your copyright. But you do have, as soon as you put ink to paper and you've doodled something on a napkin, you've got something that's copyrightable. There are very few things that are not copyrightable, and there are some things that fall underneath the category of fair use where people can use something. Things that are not copyrightable. Maps are very difficult to copyright. Information, like an index, is very difficult to copyright. However, the layout of a map, the layout of an index, those things can be copyrighted. Most maps created by the US government have a copyright on them, but anyone in the US can use those maps without worry about infringement because it belongs to the government, but that means it belongs to you to use, if that makes sense, because you're paying your tax dollars towards the government. Just a note, if you ever do work for the government, realize that you're doing a full rights buyout situation, and that's going to be available to the entire public. I've done many things for the government, and it's something you have to price accordingly. Selling full rights is not at all bad as long as you charge significantly for it. Most of the illustrations I've done in my lifespan, though, have been one-time or partial use or specific use, and thus the licensing has changed. And that's determined on the amount of exposure something receives. For example, an editorial illustration inside a magazine is determined by the quantity or the exposure of that magazine for that publication. Also, how big it's in the magazine, whether or not it's a full page illustration, half page, or quarter page illustration, determines its value. So editorial work for magazines or daily work for newspapers, the value is relatively low. That's kind of compensated by creative freedom that the art director gives you, but it's not as lucrative as, say, a billboard campaign. A billboard campaign, same image that, remember I was talking about that a crab image inside a brochure? You put the same crab image on a billboard. Standard billboard campaign is usually 6 billboards for a period of 30 days. That if you're in a metropolitan area like Seattle, that means that 5 million people are going to see that billboard. That's a huge amount of exposure. If I was creating an image for a billboard, I could probably get between $8,000 and $10,000 for it, as opposed to if I had created that illustration for, say, the inside of a brochure, which I might get $500 for. Let's say that client wants to take that $500 image from the brochure, and now they want to put it on a billboard. What do you do? Well, technically, I could, because it's a new use, I could charge them as much as I want to. However, it's always been my policy to charge a 35% reuse fee for the price or the usage in question. And that, say, $10,000. If my original reuse fee, so that I get $3,500 for that new use. Does that make sense? Let's see. I'm all caught up on questions. I'm going to check my Twitter feed real quickly. Someone is asking to be joined in. Just follow this person so that they can follow me back. This is going out to, oh, I don't know how to pronounce this name. Tia Ray in Vancouver. My email address is markmonlux@comcast.net. If you can email me your Gmail account or your Gmail address, I will invite you in. Checking my inbox real quick. Don't see any notes.
Mark, can I?
Yes, you have a question?
Just to clarify, I understood from the answer you gave me to my last question. My website is on WordPress. I'm using WordPress. So if I understood correctly, if I publish a blog, let's say once a month. And when I do so, any images that I have that are not, owned by a client, they're my, just my own pleasure, whatever, let's say, that because they're part of a blog, does that mean I don't need to register it? Is that what you're saying? Because they registered?
No, you should register it, but what I'm saying is that it can be a group registration, that all the images that you've done over a 90-day period,
Okay.
post those on your blog, and so what you would do is it would be your blog would be a periodical publication. So you want to apply
everything that's in that publication. Okay.
Right. So you would say, I call my blog Puba Spiel. So I would say Puba Spiel from January 1st through January, February, March. April 30th.
Right.
Oh, pardon, through March 2017, and then file that. And then each image would be listed in there.
Okay.
So you can put a copyright on each image. This is how newspapers and magazines do it. You can, they have to register, they have to let the Copyright Office know what photographers and what cartoons and what illustrations and what articles. Those are all individually owned by contractors that have licensed to do that for the one-time publication. So you basically treat your blog as a publication, and you put all that in there and you send it off. And you can cover everything as one joint project.
Thank you.
You're welcome.
So Mark, I don't do illustrations very much, but based on what you're saying, you could be paying a lot of money just for registering your copyright for different things.
That's true, but you say that you're not drawing, but you're using a pencil, correct?
Yes.
You're putting it on paper, you're putting a concept, an idea, you're giving it tangible form. Regardless of what type of design or format that is, it doesn't have to be a picture. This is graphic design, falls underneath the category of what's copyrightable. So what you're creating is copyrightable. When you create something for your client on a 4-foot by 8-foot piece of paper, that's copyrightable, and you need to transfer the license to that for your client, provide them the full licensing rights. Whether or not you talk to them about who registers the copyright. Now, you're saying, oh, it sounds so expensive. Well, it's only about $40 each time you register something. And I think it's cheaper online. I don't even look anymore. I just add it to my card. But it's not that expensive. For the peace of mind and security, I've had people call me up and said, Mark, someone is using the image. What are we going to do? I said, we'll go after them. I do have a bit of advice for when you do find someone using your image. This has been my tactic, and it's been extremely successful. I've never had to go to court. I send them an invoice for the license whenever I see someone using my work without permission. That one tells them that it's not theirs to use freely, and two, it allows them an easy out to pay me off so that they don't keep using the work. I've only had to do that a few times. But in all situations, they stopped using the work immediately and took it down.
So you don't even send a letter saying cease and desist, you just send them a bill?
Yeah, I send them a bill. They will cease and it's a completely different. What is a cease and desist letter going to get me? It's going to get them to possibly stop using my work. They might keep on using it until I threaten them with further action or I take further action. But if I send them an invoice, I'm immediately going after the pocketbook, and that's where people, they listen with their money. And the first thing they're going to do is say, well, I'm going to take that down so you can't claim I'm still using it. And then I'm going to call up and say it's down, I'm not using it anymore. Or they'll call and they'll say, I'm so sorry, I didn't know I was doing that. But
So
you
have you,
change the tone of the conversation significantly from being adversarial to providing them an innocent out. A friend of mine, artist named Anita Kunz, fantastic illustrator, she found that some of her illustrations were being used in Mexico. Now, to try to take care of something like that with a cease and desist letter internationally, that could have been a whole big mess and very difficult to do. But instead, she sent them an invoice, and that person ended up becoming a regular client of hers.
I was just going to ask what happens when it's somebody outside your own country that's violating, that kind of work ethics, and they continue to use it.
Well, like I said, send them an invoice first. It's a tactic that most people are unfamiliar with, and when they get it, it starts a negotiation process rather than an adversarial process. And as long as you're talking, that's the direction you want to go in. As far as the odds of you dealing with somebody stealing your work internationally, that happens once in a full moon, but when it does happen, you do want to have your work registered, and hopefully there are ways of going about it. There are organizations out there that might be able to assist you. If it's a unique situation, the Graphic Artists Guild has been known to step in and assist when a licensing infringement has happened in a unique situation. And that's a point where you contact a lawyer.
Presumably, you would take a screenshot of whatever you found as evidence. Yeah.
If it's online, you want to do that ASAP. A matter of fact, you want to timestamp that. When you do a screenshot, make sure it's up above. You're getting that little clock thing in the window. One of the things I do every couple of years is I'll take my images into Google Image Search, and I will see if my images are still popping up, especially the ones that I have licensed out to clients. Because I have a thing in my contracts where if I do an image and it's going to be going online, it's good for 4 years, and then they have to pay me a reuse fee. So I've got my calendar so that they'll ding when, let's say I did this one editorial comment for this one website. Most websites are down and gone after 4 years. But if this one is still up, and if I do my search and that image is still there, I just send them off an invoice because in my contract it says there's going to be a 35% reuse fee. I also have a clause in my contract where it's called a permission penalty clause. The client will always say, oh, yes, we'll definitely call you up and let you know when we're planning on reusing your stuff. And I said, well, that's great because that's going to save you money. And they go, what? I said, well, right here it says that if you don't call me up before you reuse it, not only do I get my reuse fee or whatever fee that we agreed upon, I also get $500. And I get phone calls now when clients say, oh, we're reusing your work, because they don't want to have to pay me that $500. I also don't see my work up on the web too often past those 4 years, but when I do, sending them out that 35% reuse fee, hey, it's good for another 4 years. I've had to do that once. Questions? We got 15 more minutes, folks. One of the things that you should have in your contract, most people are really worried about what type of terms to have in their contract. And terms are a relatively simple thing to find out and learn about. The really important thing is what becomes before terms. Terms is going to basically say when you get paid, when the kill fee is going to happen. Oh, by the way, establish a kill fee, if-then scenario, so that if you, even if the client doesn't like your work, you put in the effort, so you still get paid. The client can't say, oh, I didn't like what you came up with, what you drew all day long, and we're not going to be able to use it, and we're not going to pay you. They can't say something like that. But a client can say, the weather's atrocious, no one's going to be there, the event has been canceled. So in that situation, you have to decide what's going to be the kill fee. How easily are you going to let them off since you're not going to be able to work that day? It all depends on whether or not you've had to travel to get there, what type of compensation has to be done. When I do an illustration for a client, I typically have a 50% kill fee established from the get-go, and then it says in my contract for every percentage of the work done until completion, I can charge them that completion. So if I've completed the project and the client said, we're not going to use this, I still get paid 100%. Just because they enacted the kill fee, it's not, they should have enacted the kill fee as quickly as possible, because I always get at least 50%, if not more. But I very seldom have had a client kill a project. They have sometimes, but when they have, the project's already done, and so I've always gotten 100%. Yes.
So Mark, I wanted to thank you for when I spoke with you. I don't know if you remember, and I asked you a bunch of questions, and that particular project was my worst client, nightmare client I've ever had, and I ended up having to fire her. But I got 50% because of your advice. So I thank you for that. Actually, when she realized that it was a 50% non-refundable, she made me do half the work in order to get her money's worth. But which is fine, because she was such a horrible client that I just wanted to get rid of her.
Oh, but you didn't have to do half the work. As soon as a client says kill fee, you get half. Because it's not only the work that you were doing, but you've scheduled that time block to do that work.
Right.
The inconvenience of you having to reschedule that time block alone should have been just worth the kill fee.
Well, I mean,
but I'm glad you came to a compromise with the client and you both parted.
Yeah. I just wanted to stop that project. It was so horrible that I didn't want to do it anymore. And at least I got paid.
I have another question here. This one's from Shirley. Can you talk about trademarking a product name, not an image? Also getting a TM for the name of your company so no one else can use the same. Okay, now we're getting into a whole fun bit of advertising law. Trademarks are different than copyright. And the thing is, there are laws both federally for federal trademarks, and there's also laws for state trademarks. And it's a whole different kettle of fish. Trademarks are sort of like a club. There's a little R that means that you've registered your trademark. And then there's a TM, which means that it is your trademark. So you can put a TM next to anything and say it's your trademark, even though you haven't registered it. An R next to it means that not only has it been registered, but it has been approved. So in order to get a trademark approved, basically your trademark goes to the Trademark Society, or whether or not that's the federal one or the state one, you'll probably want to do both if you want to go this route. The people in that club look at your trademark, and the people that have the trademark closest to yours can say yes or no. And they don't and if they say no, they don't have to give a reason no, it's just been denied. So that can cause a lot of problems. What you can do, though, is you can make an argument that it's been in use. For example, I have used the phrase home of the creative mind for the last 25 years on a lot of my documents, and I've always put a TM after it. Because I've used that phrase, home of the creative mind, for 25 years, even though I haven't registered that phrase, it's been in use and it's been recognized. If someone else comes along and says, hey, this is my catchphrase, home of the creative mind, I could potentially go up to them and argue a case saying, I've been in the marketplace longer and it's mine, not yours. This actually did happen. There was a graphic artist, and he was using the phrase home of the creative mind. But rather than confront him about it, I decided to let it go because I know something about graphic artists. They are short-lived little animals for the most part. I know that of the 10,000 people that enter in every year, 90% are going to die out the first year, another 90% are going to die out the second year, another 80% are going to die out after the fifth year, and only 4 out of 10,000 people will still be doing the work after 10 years. I did a survey way back in the 80s about this. So I knew that it wasn't going to be worth the bother to confront him about this because he wasn't going to be around in 5 years. I decided to wait 5 years and then say, hey, listen, I've been using this longer than you have, but I knew the odds were with me from the get-go, and he's no longer around. But if you are going to, I would suggest going ahead and putting a TM next to whatever it is that you're planning on trademarking. But trademarking can be costly, and you might be denied. I had one of my clients, Bear Creek Toys. They had this wonderful bear mascot called Wiley, and they decided to put together what they were calling the Wiley PI Detective Kit. And this was a great box. It had one of those little periscope spy things, decoder stuff, invisible ink markers, I designed this cute little passport with Mylar over the top of it so you could draw mustaches on your face and do stickers on it and stuff. Whole big ensemble. They printed, this package was not, and I also did the packaging for it. And it was not cheap to produce this. And they produced this, and they had thousands of units made. And then they get a letter saying that their trademark was denied by Wiley and Sons Publishing, because even though that was when publishing was starting to make an entrance into making toy products, and they thought there might be confusion with the name Wiley. They could have fought for it in court, but instead they made a big giant bonfire and just burned all the product and marked it as a loss. So there is a danger to be had because there's no legal recourse if they say no. Now, also, trademark is different than copyright because it's more about branding. And there are all these different types of branding laws that exist. You might have seen parody ads where people take familiar looking trademark brands but put different names on it. Doing that as something other than parody can get you into trouble. Parody is one of those categories of fair use. When I mentioned fair use before, parody is a permissible form of fair use. Another form of permissible fair use is if you're a teacher and you're using something to explain or educate. If you give adequate references for your resources and you don't use it in its entirety but just partially, then it's okay to use something. Too many teachers take that a little bit too far and then they get caught out on it. There's the guild suggests, by the guild I mean the Graphic Artists Guild, the guild suggests having an ask first campaign, which is if you ever want to use something, just ask who created it. The internet's great. You can find out whoever owns anything. I know this one designer, she called me up and said her client wanted to have Betty Boop on a baby shower invitation, and she wanted it to be a pregnant Betty Boop. And I said, okay, in order not to get trouble, just go ahead and license that. She said, who do I call? Well, King Syndicate owns Betty Boop. So I said, tell her what the usage. Tell her it's going to be a quantity run of 200. Let her know the size. Let her know that it's a one-time deal. And they came back and said, oh, yeah, the licensing is, that's only going to be $150. So she got permission for $150 to give her client an authentic Betty Boop, a pregnant one on the bedding, on the baby shower invites. And a lot of times, people that you call up or who will contact you will ask permission and will just give it to you free because you asked for it. I had a person, I once had a cat that had bronchitis, and I had to get an inhaler for my cat. And the instructions that came with the inhaler were so oblique, and you just couldn't understand these instructions. So I drew some instructions on how to use a cat inhaler, and I posted them online, and I sent them to the company. And I said, hey, you might want to send this out. I was hoping that they might consider licensing it. It was on my blog. And it's been there for years, and I get a contact from a teaching institute of this veterinary association asking me permission for them to use it in their presentation. And I said, yeah, go right ahead. No use fee. Another time, and there's times when you want to say yes for the right reasons. Another image on my blog was a little guy with it was a little tiki guy holding a torch. And this college student wrote to me saying, hey, I'm having a tiki party on my campus. I want to post this on my blog. Well, I asked him to give me his blog address. As soon as I saw his blog address, I immediately said yes, because his blog site was tagged into the university site, which meant that as soon as my image went in there, the analytics for it was going to shoot it all the way up to the top of the charts because hundreds of thousands of people were going through the university website. That tiki image overnight was in the top 12 and has pretty much stayed on the first 2 pages of Google ever since. And it's been, over 12 years since then. And we are at the hour mark. I'll take one last. Roseanne writes, in British Columbia, we have 3 possible companies' names when we register a company in the province in case one of them is already being used. Well, that's interesting. Now, I'm going to show you some books that I think, if you can get a hold of them, would be really great. These 3 books came out quite a while ago, and they're all written by a person called Lee Wilson. And the first is The Copyright Guide. That's a wonderful book explaining copyright in layman's terms. Another one is the Trademark Guide, which was really helping me understand trademarks, because that's a nasty can of worms altogether. And we haven't even talked about patents. I want to talk about patents before you guys leave. And I really love this one, the Advertising Law Guide. This is an if-then scenario situation. For example, when can you use a picture of a public police officer? If you took a picture of a police officer on the street, when or could you use it in advertising, or what forms of publications or marketing can use that picture of that policeman? I mean, he's a policeman, he's in public, but he also has his own rights. So if I was to take a picture of him, swilling a beer at a beer garden, that might cause some problems unless he endorsed it to be used at a policeman's beer garden. So yeah, or taking pictures of children in parks. That's a big no-no, because a lot of children are on the run from abusive families. So you can get in a lot of problems for that. If you're doing a project with the school, find out what you can do with that school in the way of children, because sometimes a client will come to me and say, "Oh, Mark, can you also take pictures?" Well, you don't want, unless a waiver has been signed by at a school, you don't want to take pictures. Anyway, that's something for a whole another period of time. But I do want to talk about licensing. I'm going to get something to explain my point. Patent, doing a patent as opposed to doing, say, a copyright or a trademark. A patent is when you lay claim to an idea. So a while ago, I made this, which is a horror movie bingo card. And on the back are different little scenarios that happen during the course of a horror movie. And if you get one of the rows, you win. Something like bad acting, infection, zombies, knife, mushrooms, burnt light bulb, something like that. I made a whole bunch of these with different scenarios. Now the illustration, I can go ahead and I can copyright the illustration. So if someone uses the illustration, then I could go after, it would be protected. But the concept, the idea of a bingo card with scenarios being printed out into a grid, that's not copyrightable. I would have to file a patent for that. But patents run between $4,000 and $5,000. And I'm not sure if I want to invest that for the bingo cards. I'm just going to see how popular they are. If someone else wants to start making bingo cards, I might lose out. But that's the difference between a patent, a trademark, and a license. And I see Philip came at the last minute.
Hi, Mark. Sorry, I was earlier. I'll catch your European tour.
Okay, sounds like a plan, sir. Okay, we're at the hour mark. If there's not any more questions, I'm going. Oh, there is one more question. In British Columbia, we have to. Oh, pardon me. The cost in Canada per copyright registration is $65. I believe that in the U.S. it's between, if you do it with forms, it's between 40 and 45, and if you do it online, it's between 35 and 40. I highly recommend that you do it online, because that way you send in files. Also, if you file online, it's immediate. Whereas if you mail it in, it's only until the image gets postmarked or arrives at the Copyright Office that the registration takes effect. So you're saving money. And the reason I say don't mail it in is because remember that big anthrax scare we had way back when, where the mails got log jammed? It was taking up to 3 months for a letter to go to the Copyright Office. So a lot of people started to using courier services like FedEx so that the item would be signed when it got arrived and prove that it got there faster rather than a 3-month delay. But now that they've got the internet up and running at the Copyright Office, that's all the better. And I really don't see any reason not to do it unless I know that some of the forms may not be available online. I'd also like to pump a couple of my other videos. I've done some videos called Ask Mark on my website channel, Mark Monlux. Also, me and my friend Daniel Abraham have started doing a little video series called Law and Artist. And we talk about things like this in our first few videos were about 5 or 7 minutes in length, but then we started covering things in nice, easy chunks of 3 minutes. And just watch all those. I think we're going to convert over to doing an audio podcast because doing all the video editing has been a real pain in the neck for me. And I wish I was going to the IFEP conference this year, but it's my wife's and mine 30th anniversary, and we're going to use that cash to go out and have some fun instead. But I'm looking forward to seeing you all the next time around.
Thank you, Mark.
You're welcome. Thank you guys for attending. If anyone watches this video and you have questions that weren't answered, please leave them in the comment sections down below in the YouTube channel, and I'll see what I can do about answering them.
Thanks. Bye.